Hey everyone, welcome back to another episode of SDL. Greg and I are back from summer vacations, summer breaks. Greg, how was your summer?
Pretty good. I'm looking pretty tan, right?
You're very tan. You had a nice time down the shore, right?
I did.
All right, we're taking our last summer trip coming up, but we're gearing up for the fall season and going to be producing some more content for all of our loyal SDL viewers. So in today's episode, we want to discuss an issue that we had previously briefed back in the spring, back in April. There was a decision from the FTC that a rule is going to go into effect next week, actually, in early September, banning non-compete agreements.
Right. So for those that watched the previous video, just a quick recap. Most people know what non-competes are, right? They're a way for employers to enter into a contract with their employees to make sure that the employees cannot then go out and seek employment elsewhere for a limited period of time in a particular region, right? And so what the FTC decided in the rulemaking authority was that those really were prohibiting free market, right, and the restraining employees from seeking employment elsewhere, which to them felt like suppressing the economy and suppressing the marketplace. And so really what happened after that was the bunch of plaintiffs from the Chamber of Commerce, Ryan LLC, decided to file suit against the FTC, right?
Right. So good recap on that. So now we move forward to the Ryan case. Ryan's a global tax leader in the industry. They filed suit to say that the rulemaking power of the FTC was not proper in this case, and the court imposed a nationwide injunction saying that it was arbitrary and capricious what the FTC did in the rulemaking, and they do not have substantive rulemaking authority, and that belongs to Congress. So separation of powers argument, and that the district court in Texas agreed with that argument. So they imposed a nationwide ban on the non-compete agreements going into effect come after Labor Day.
Yeah, and this decision was actually interesting because most times you'll see rulings or holdings like this that are really limited to the plaintiffs. We've seen that in the Corporate Transparency Act case, right, where it was limited just to that particular plaintiff. This one was a lot broader, and the Northern District of Texas Court really found that this applies to everybody because the FTC doesn't have this rulemaking authority, and their rule in itself was arbitrary and not based on any evidence to support why it needed to be so sweeping. So it's pretty interesting that it applies to everyone. Obviously, it's going to get appealed. The FTC has indicated that this decision will be appealed. And what happens at the appellate division, we'll see as to whether there's a stay on this lower court decision or whether it's going to be enforced. As it currently stands, though, non-competes that were enforceable before this decision are still going to be enforceable. So this kind of dials back the FTC. Right?
I would imagine that this is going to make its way up to the Supreme Court at some point sooner or later, unless the FTC decides to withdraw that rule and come up with another rule, which highly unlikely. So I assume we're going to see this at the Supreme Court as it makes its way up through the different appellate levels.
Yeah, and this will play out. And in the meantime, while this is in the appellate division, you're seeing states that are going to try to implement similar types of bans on non-competes, right? There was one in New York that was proposed last year that got vetoed by the governor. New Jersey doesn't have a ban on non-competes, but there are certain standards really that every state has as to whether a non-compete is enforceable. So it's important for employers to understand that, hey, this rule is not going into effect. You may still need to revise your non-compete agreements to make sure that they're complying with the well-settled established law.
Right, so in New Jersey specifically, it must be reasonable. I mean, that's a good standard to follow. That the agreement must be reasonable. It must have a legitimate business purpose, and it must not unduly harm or prejudice the public at large. So those are some standards that are within the scope of the New Jersey's rule on non-compete agreements, and I'm sure other states have similar laws as well as New Jersey. So it's an evolving area of law. I think the FTC, in their rulemaking authority, wanted to consolidate everything as to one overarching rule. So maybe good intentions in mind, but the execution, obviously, at this point, isn't going to occur.
So the bottom line is that non-competes are still enforceable in this country, but be mindful of whether your particular agreement is actually enforceable based on the well-settled law. Stay tuned as to what your particular state is doing on this issue. We'll obviously keep you updated.
Thanks, everyone.
Take care.